Let's take a look at a joint enterprise. Sometimes companies are linked because they're joint employers that maintain employment relationships with some of the same employees. There are a few circumstances where joint employment might exist. For example, when companies get their workers from temporary staffing firms or other labor providers, or when companies agree to share staff. These arrangements do not automatically lead to joint employer liability, but they have the potential to do so if both parties function directly or indirectly as employees. Recognition of joint employer liability has expanded in recent years, but legislative efforts are underway to roll back expansion. Questions from joint employment frequently arise in agriculture, where farm labor contractors, FLCs, are used extensively to provide farmers with seasonal labor. These agreements raise questions about who is legally responsible for the often substandard conditions under which farm workers toil. In one such case, a farm was found to be a joint employer of workers harvesting cucumbers and shared liability for a host of employment law violations with the FLC. Joint employment is also an issue when employers use temporary staffing firms. Arrangements vary considerably, but the temp agency usually assumes many of the client company's human resource functions. Under these circumstances, a temp agency is most often considered the employer of its temps. A client company might also be deemed a joint employer of employees it procures through a temporary staffing firm. How should companies that use temp workers supplied by temp agencies deal with those workers and performance problems when they emerge? If temp workers complain about inadequate treatment or request medical leave? In one such case, the client firm responded to employee complaints by deciding to obtain all part time and temporary employees through temporary staffing firms rather than hire them directly. Because the firm exerted substantial control over the temps and their work, they were found to be a joint employer, sharing liability with the temp agency for violations of the National Labor Relations Act. Employers cannot assume simply because they obtain workers from temporary staffing agencies or use the services of employees from contract firms that they're free of legal obligations to those workers. The degree of control extended over the workers is a key factor. The only way not to be deemed an employer is to avoid acting like an employer. Actions such as supervising, training, selecting, and disciplining individual temps should be avoided if an employer does not want to risk being deemed a joint employer of its temps.